You're on a 2-year conditional green card, but you're getting a divorce. How are you going to remove the conditions now? Talk about stress, right? Your marriage is not working, and now you have to worry about losing your green card too? You made the US your home, and now are you going to have to leave just because you're getting a divorce? Nope, you don't. What you have to do is get an I-751 waiver. Hi, I'm Shariq, the South Asian attorney. I'm licensed to practice law in the US, and I help people worldwide with American immigration law. So what's a conditional green card? When you get a marriage-based green card and you've been married for less than 2 years, the government doesn't give you a permanent green card right away. The reason? They want to make sure that your marriage is real. So to remove those conditions, you normally have to file Form I-751. And this is within 90 days before your green card expires. If your marriage is still intact, you and your spouse file together. But if you're getting a divorce, that's where things get a little tricky. So then, can you still remove conditions from your green card if you're getting a divorce? Yes, you can. You can apply for I-751 with a waiver, meaning that you don't have to file jointly with your spouse. But here's the key. You need to prove that your marriage was real. Immigration is going to look closely at your case. They'll want to see that you and your spouse entered the marriage in good faith, and that it didn't just exist for immigration purposes. So what does that really mean? It means that you need to show evidence, things like a joint bank account, shared lease or mortgage, utility bills in both names, photos together, affidavits from friends and family confirming your relationship. The stronger your evidence, the better your chances of getting approved. If your divorce is already finalized, great. That's the best case scenario, because now you can submit your divorce decree along with the I-751 waiver request. But what if your divorce isn't final yet? That's where things get a little tricky. You still need to file the I-751 before your 2-year green card expires. But instead of submitting a divorce decree, you can include proof that your divorce is in progress. USCIS will usually give you close to 90 days to submit the final decree. So make sure that your divorce gets finalized within the 90 days of filing your application. One important thing, you don't want to wait too long. If you delay filing, you could risk being placed in removal proceedings. If you're already getting divorced, it's best to start the process as soon as possible so that you have the divorce decree when it's time to get the conditions on your green card removed. Some people file the I-751 jointly with their spouse, and then things start falling apart. What do you do then? Well, you can amend your I-751 petition to request a joint filing waiver. This means updating the USCIS and letting them know that you're no longer filing together. But again, you need a divorce decree from the courts. There are a few mistakes that people make that can cause big problems. Waiting too long to file. If your green card expires and you haven't filed the I-751, you could be placed in removal proceedings. Not having enough evidence. You still need to show that your marriage was real, even if it's ended. Filing the wrong form. People sometimes mistakenly file Form I-90 instead of I-751. Form I-90 is for renewing a permanent green card. But if you need to remove conditions from your green card, you need to file Form I-751. Getting divorced on a conditional green card can feel overwhelming, but it's not the end of your immigration journey. If you handle the process correctly, you can still remove the conditions and get your permanent green card. Take care, and I'll see you next time.